Hello, I am the digital avatar of Tanner Hukezeli. While Tanner is busy working to get inventors and brand owners the protection they need, I am here to give you some information that might help you on your intellectual property journey. As always, the information in this video is provided for information purposes only and does not constitute legal advice. If you do want advice that is specific to your circumstances, please reach out to our firm or another patent agent or trademark agent for qualified assistance. Today, we're going to talk about divisional patent applications in Canada, including what they are, how they come about, and some of the pros and cons of using them. Let's start with the basics. In Canadian patent law, each patent application is supposed to cover only one invention. If your application describes or claims more than one inventive idea, you can choose to, and may be required to, limit your patent application to one of those inventions and split the rest out into separate patent applications. That's where divisional patent applications come in. A divisional application is a new patent application that's carved out from an earlier one, often called the parent application. The divisional application allows you to pursue protection for the additional invention, while keeping the same filing date and priority date as the parent application. This means that your divisional application isn't exposed to prior art that came out after the filing or priority date of your parent application. Now, why would you file a divisional? There are two main reasons. The first reason is because the Patent Office tells you to. If the examiner at the Canadian Intellectual Property Office, CIPO for short, reviews your application and finds that your claims cover more than one invention, they'll issue a unity of invention objection. You'll be asked to choose one invention to keep in the parent application. The other invention or inventions can be pursued in a divisional. The second reason is because you choose to. Even if the examiner doesn't raise a unity objection, you might decide to file a divisional on your own. Maybe your original application describes a second invention that wasn't claimed, and you want to protect it separately. Just remember, you must file the divisional before the parent application is granted. Once the parent becomes a patent, it's too late to file a divisional. Now, let's talk about the advantages of filing a divisional. You can get broader protection by securing multiple patents from one disclosure. You preserve your priority date, which helps protect against intervening prior art. You can tailor each patent to a specific invention, making enforcement and licensing clearer. You gain flexibility. Each divisional is its own property right, which can be sold, licensed, or maintained independently. But there are also disadvantages to consider. Each divisional is a new application with its own filing, examination, and maintenance fees. There's a risk of double patenting, especially if the divisional is filed voluntarily and the claims overlap too closely with the parent. In Canada, this can be a challenging problem because there is no easy fix like in other countries. An examiner might not agree to let the commissioner decide on unity, potentially adding cost to examination. Managing multiple applications adds complexity. You'll deal with separate examinations, deadlines, and claim strategies. And remember, filing a divisional does not extend your patent term. Both the parent and divisional expire 20 years from the original filing date. So, what's the best practice? If you haven't filed your parent application, a Canadian patent agent might recommend that you file separate applications, each with their own distinct set of claims for one invention. This is a good way to avoid having to navigate Canada's unity of invention requirement while managing the risk of double patenting. You may find yourself having to address the question of unity after the original application is already filed, either because you are facing a unity objection from an examiner or because you've decided you want to protect a second invention described in the original application. The recommended practice for dealing with a unity objection raised by an examiner has undergone some changes. Until recently, courts typically would not contradict an examiner's decision on unity of invention. So, when an applicant divided the claims into separate applications, after a unity objection from an examiner, it was considered forced, and the claims were typically not open to invalidation on the basis of double patenting. In 2023, a case went through Canadian courts, which continues to affect this practice at the time of this video. Division following a unity objection made by an examiner is likely to be considered voluntary and may no longer be enough to avoid the risk of double patenting. The court did not specifically say what now constitutes forced division. However, refusing to divide after an examiner's unity objection might bring the question of unity directly before the Commissioner of Patents, If the Commissioner of Patents issues a notice directing that the application be limited to one invention, then this should be sufficient to say that the divisional application was forced by the Commissioner, and therefore there is no double patenting between the patents that issue based on the parent and divisional applications. If you are trying to protect a second invention voluntarily, consider including claims to the additional invention in the original application. This should provoke an examiner to raise a unity objection, which can potentially then be brought before the Commissioner. If the Commissioner issues a direction to limit the application to only one invention, this should help protect against double patenting challenges. Remember that trying to force the unity issue to a decision by the Commissioner isn't without its risks. An examiner may refuse to send the case to the Commissioner for decision, and Canada recently adopted requests for continued examination fees after the third office action and then every second office action after that. So if the examiner does not send the matter to the Commissioner for a decision, then this approach could result in a costly back and forth with the examiner. Also, Canada recently adopted surplus fees for each claim over the 20th. So, including a large number of claims into a parent application, hoping to provoke a unity objection from an examiner can come with added expense. However, if you are forced to divide by the Commissioner, this should seriously limit the risk of invalidation for double patenting later. Given the complexities of the options I've discussed and the potential costs involved, they should be exercised with care and with guidance from a Canadian patent agent. In summary, divisional patent applications are a powerful tool, but they must be used strategically. They allow you to protect multiple inventions from one disclosure, but they come with added costs and legal risks. Always consult with a registered Canadian patent agent before filing a divisional, and make sure you file it before the parent application is granted. Thank you for joining me today. I hope this discussion has helped clarify how divisional patent applications work in Canada and how they can fit into your broader IP strategy. For more information, please visit us at wilsonpatents.com or reach out to Tanner or one of the other agents at CWC Intellectual Property. We're ready to help. And if this video has been helpful to you, don't forget to like, subscribe, and share.